Several significant legal issues were addressed when the Supreme Court of Ohio conducted oral arguments in February 2026. The court heard 8 cases, including a challenge to a city's restriction on unrelated people living in the same residence and the conviction of a driver who hit and killed a firefighter at an accident scene. Reed Havel rented out a home he owns in Kent, in an area zoned for single-family residential dwellings. Havel had 6 renters living in the home. The city notified Havel that he was in violation of ordinances that prohibit more than 2 unrelated individuals from living in a single-family dwelling. Havel's request for permission to use the property as a group home was denied. He challenged the no more than 2 unrelated individuals in the same home rule to Portage County Common Pleas Court. The court ruled the city law was unconstitutional. The Kent Zoning Board appealed the decision to the 11th District Court of Appeals. It found the law was constitutional, and the city could have an area designated for family residences. Havel appealed to the Supreme Court and argued that the Ohio Constitution grants fundamental rights to property owners, and the law was infringing on his rights. Havel maintained the city has no good reason to prevent more than 2 unrelated people from living in the same home.
There are other ways of doing this. Every other city in Ohio has found another way to do this to advance single-family residential without this kind of occupancy restriction at this point. The sky didn't fall in Bowling Green. They limit the number of tenants by bedroom there. You can also do it by square footage. You can also do it by available off-street parking spaces, all of which are far less intrusive and less invasive.
The city maintains the regulation encourages single-family homes in one distinct area of Kent. It noted that for 100 years, Ohio courts have viewed zoning restrictions as proper.
Isn't the city really drawing the line to prevent housing for Kent State students?
There's no evidence of that in the record, Your Honor.
Okay, but isn't that what we're really talking about?
Well, Kent is a college town, but again, this is only in the R3 district. This does not apply to any other districts within the city of Kent.
I've heard you say that, well, there could be parking problems if there's more people living in the house, and that this is kind of a de facto density regulation. But what you say in your briefs is this is not about density. So help me understand what the purported justification is.
Well, the R3 district, again, is to encourage higher density with single-family higher density within the R3 district.
In a second case, the court considered an appeal of a Cleveland man's 15-year to life in prison sentence for striking and killing a firefighter at the scene of a highway accident. In November 2022, the accident on Interstate 90 near Cleveland caused a major traffic backup. While most drivers moved slowly in the far 2 right lanes, some drivers, including Leander Bissell, ventured into the left lanes where emergency crews were responding to a flipped car. Bissell weaved past police cruisers and into the far left berm to pass traffic. He was going 49 miles per hour when he struck firefighter Johnny Tetrick. Tetrick was walking across the lanes from the right side where traffic was moving back to the left lanes where the accident had occurred. Tetrick died from his injuries, and Bissell, who did not stop after hitting him, was arrested later. Bissell was charged with felony murder based on committing felonious assault. He appealed his life sentence, arguing his conduct was reckless and not knowingly, and he deserved a lesser sentence. In a 2-1 decision, the 8th District Court of Appeals agreed and found his actions were reckless and that he could be charged with involuntary manslaughter, which carries a lower sentence than felony murder. The Cuyahoga County prosecutor appealed the decision to the Supreme Court. The prosecutor argued the trial court correctly determined that Bissell acted knowingly, not recklessly, and is guilty of felony murder.
When you take the case law and the statute together, knowing, can you define it?
Knowing is when someone is aware that their conduct will probably cause a certain result. And so that means that they are aware that what they are doing will have greater than 50% chance of causing the result. And so here, when you speed through a closed-off accident area for which as many as 7 police cars are blocking the left two lanes. When you do that, you know for the accident area that there will be first responders on foot.
Bissell's attorney argued his client was an impatient driver and was reckless. Given all indications that the accident occurred in the left lanes, Bissell did not expect a firefighter to emerge from moving traffic on the right. He deserves a lesser sentence that still leads to time in prison, he argued.
He, with 27 other people, should have waited their turn to get into the far right lanes because you have cruisers with activated lights creating a traffic control scene. That's what he should have done.
Well, I mean, I think every argument, statement you just made, Chief Justice Kennedy, connotes recklessness.
Well, I understand that argument.
Yeah.
But he didn't stop.
He didn't stop, right?
He hit the emergency person at 49 miles an hour and kept going.
But here's what you can't do as a fact finder. You can't provide speculative inferences. There's no evidence as to why he didn't stop. There's none.
Chief Justice Sharon L. Kennedy announced the court will take the arguments under advisement and inform the parties of its decisions. You can follow these and other cases before the court by visiting our website at supremecourt.ohio.gov and signing up for case activity notifications. The court meets for oral arguments at the Moyer Judicial Center in Columbus. Each session begins at 9 a.m. You can also see them live online at supremecourt.ohio.gov.